Hello, and welcome. I'm Dr. Mark Leiser, and this lecture forms part of an ongoing series on the Digital Omnibus, legal certainty, and the future direction of EU digital law. Across this series, I'm trying to do something quite simple, but I think quite important, to push back against slogans, easy alarmism, and increasingly familiar tendency to treat every attempt at legal clarification as automatically a threat to rights. This lecture focuses on one of the most politically influential lines in the current debate, the civil society, and EDRi claim that the omnibus clarification on the scope of personal data would somehow weaken the GDPR by making the concept of personal data subjective, optional, or dependent on what companies want to believe. I want to suggest that this line is not only mistaken, but is actively unhelpful. It mistakes contextual legal analysis for deregulation. It mistakes actor relative assessment for arbitrariness, and it mistakes doctrinal fog for the protection of rights. At the heart of this issue is a basic question. When we ask whether data is personal, are we supposed to apply a realistic legal test to the actual actor, actual context, and actual means reasonably likely to be used? Or are we supposed to collapse all context into one and assume that if anyone somewhere might be able to identify a person, then the answer must always be the same for everyone? My position is well known and clear. The GDPR remains coherent only if its trigger logic is legally disciplined, fact-sensitive, and governable. That does not mean companies get to self-certify their way out of the law. It means the law should be applied seriously. It means recital 26 should matter. It means courts, lawmakers, and regulators should care about realistic identifiability rather than abstract perimeter panic. So in this lecture, I will explain why I think the EDRi and broader civil society line gets the law wrong, why that matters far more than the GDPR itself, and why this debate is really about the rule of law, institutional balance, and the integrity of the wider digital acquis. With that in mind, let's turn to slide 2. This lecture is a direct rebuttal to a powerful claim in the Digital Omnibus debate, that clarifying the GDPR's definition of personal data would weaken rights by allowing companies to subjectively decide that data is non-personal whenever they say they cannot identify someone. That claim matters because it's persuasive. It sounds like a defense of the GDPR. It sounds like a defense of fundamental rights. And it sounds like a defense of ordinary people against strategic corporate interpretation. But in this lecture, I want to argue that that claim is wrong. More than that, I'm going to argue that it's legally dangerous. It's wrong because it confuses contextual legal analysis with fragmentation. It's dangerous because it treats a fog as if it were some sort of fundamental rights strategy. And it's politically powerful because it converts a hard legal architecture question into a simple morality play. Rights are on one side, rollback of protections on the other. But that's not the real choice. The real choice is whether the GDPR's trigger can remain intelligible, realistic, and governable. Before the GDPR can scale obligations by risk, it must first explain when it applies. Before we can talk about lawful bases, transparency, access, erasure, security, DPIAs, or enforcement, we need to know whether the data is personal data for the actor and processing context at issues. So the core line for this discussion and this lecture is simple. Rights need discipline, not fog. So this is not a lecture against civil society. EDRi is an important actor in the European digital rights politics. And it's legitimate to scrutinize the omnibus and to worry about weak drafting or insufficient safeguards or poorly designed AI provisions. I share some of those drafting concerns. And this lecture is not a defense of every comma in the Commission proposal, but it is a defense of the principle of legislative clarification. And it is a critique of what I will call perimeter panic, the instinct to treat every attempt to discipline the GDPR trigger as a rollback, every contextual result as fragmentation, and every actor relative analysis as a loophole. That instinct may feel protective, but legal uncertainty is not the same as the protection of rights. Fog is not a fundamental right. Let's start with what I call the snake oil that EDRi is selling. Because if you look at their proposals and you look at their reports, they sell three propositions. First, the elastic scope of the GDPR protects rights. The broader the definition of personal data, the safer everyone is. Second, the same data should mean the same legal answer. If data is personal for one actor, they should be personal for everyone in the chain. Third, legislative clarification appears to be a rollback if the omnibus clarifies that identifiability depends on the realistic means available to a given actor, which must be a narrowing of protection. The problem that with each of these claims sounds more secure than it really is. A maximally elastic trigger does not give us certainty. It gives us an unstable boundary. It gives us a legal system in which the safest compliance answer is always to assume the broadest plausible scope, even when the realistic risk of identification is low, remote, or structurally blocked. It encourages defensive classification. It pushes actors to treat every uncertainty as personal data because no one wants to be the test case. That is not principled rights protection, and it often results in performative compliance. The same data, same answer claim has the same problem. It sounds objective, but it's actually refusal to take facts seriously. If one actor has the key, the enrichment route, the account graph, and the legal authority to relink, while another actor has none of those things, treating them identically is not objectivity. It is fiction. And the rollback claim fails because clarification is not inherently deregulatory. Legal certainty can weaken rights if it's drafted badly, of course. But legal certainty can strengthen rights by making the law foreseeable, proportionate, and enforceable. A right is not strengthened by making its trigger impossible to explain. So what does the EDRi line deliver in practice? It delivers more uncertainty for controllers, processors, researchers, SMEs, and public bodies. It creates more room for interpretive drift through guidance, enforcement signaling, and institutional preference. It gives more power to those who get to define the legal perimeter after the fact. And it gives less democratic clarity about where the GDPR actually begins and ends. That's why I call it snake oil. It promised certainty through maximal scope, but it delivers discretion, opacity, and a trigger that is increasingly controlled by the institutions and actors best positioned to interpret it. And once again, that is not a fundamental right strategy. So now we come to the heart of the legal issue. EDRi treats actor-specific results as fragmentation, but the GDPR treats identifiability as a contextual application. That legal test is not arbitrary. It is not vibes. It's not corporate self-certification. It is Article 4.1 read with Recital 26. Is the person identified or identifiable? Taking into account means reasonably likely to be used, including objective factors such as time, cost, available technology, and technological development. Let me make this concrete. Imagine controller A. Controller A holds the original dataset and the key. It can relink records to individuals. It has the organizational knowledge, the technical route, and the practical ability to identify. For A, the data is personal data. Now imagine processor B, or recipient in B's position. B receives the same dataset, but only after robust pseudonymization. B does not have the key. It has no legal right to obtain the key. B has no enrichment route. B is subject to contractual restrictions, technical separation, access controls, and anti-re-identification obligations. On those facts, identification may not be reasonably likely for B. Then imagine recipient C. C receives the same dataset, but C also has account data, device graphs, market data, location traces, or another realistic enrichment route. C can combine the information in a way that makes identification foreseeable. For C, the data may again be personal data. Same dataset, different actors, same legal test. That is context, not fragmentation. The EDRi error is to assume that different outcomes necessarily mean different laws. They do not. The same legal standard can produce different results when the facts differ. That is ordinary legal reasoning. Think of negligence. The same conduct may be reasonable in one factual environment and unreasonable in another. Think of confidentiality. The same information may be in public in one setting, but confidential in another. Think of risk regulation. The same object can be harmless in one use and dangerous in another. Law does this constantly. What matters is not the compulsory sameness of outcome. What matters is the disciplined application of a common test. Now, this is crucial. Actor-relative reasoning is not actor-isolated reasoning. B does not get to pretend it lives in a vacuum. If B can realistically obtain the key, if the transfer design allows relinkage, or if B has a practical route to enrichment, if onward disclosure creates foreseeable identification or re-identification, or if contractual safeguards are meaningless in practice, those facts count. Contextual realism is not a loophole. It is a demand that we count the real risks and reject the imaginary ones. The omnibus fight is therefore really a fight between two models of identifiability. The first is an abstract or elastic model. Under this model, hypothetical re-identification is considered sufficient. If someone, somewhere, in some possible future, could identify a person, the data remains personal data for everyone. Scope expands because imagination expands. Soft law, enforcement anxiety, and risk-averse compliance then do the rest. That model looks protective, but its boundary is unstable. The second model is the contextual or realistic model. Under this model, recital 26 means what it says. We ask what means are reasonably likely to be used. We assess the matter ex ante, in concreto, and by reference to the actor and processing environment in question. We count real routes of relinkage. We count foreseeable enrichment. We count on onward disclosure. We count the technical, organizational, legal, and contractual realities of the processing chain. But we do not count pure speculation as fact. That's the difference between protection and panic. EDRi's anxiety is therefore understandable. The worry is that companies will abuse contextuality. They will say, we can't identify, therefore the data is not non-personal, therefore the GDPR disappears. And that worry should be taken seriously. But the answer to abuse is not legal fiction. The answer is a better test, better safeguards, better anti-circumvention rules, and better evidence requirements. If a company claims it cannot identify, it should be able to show why. It should show the technical separation. It should show the absence of a key. It should show the absence of enrichment routes. It should show access controls, contractual restrictions, logging, organizational separation, auditability, and credible measures against relinkage. In other words, the answer is accountability. The abstract model does not solve abuse. On the other hand, it just makes the perimeter so broad and unstable that everyone operates under suspicion. And when everyone operates under suspicion, compliance becomes defensive. The actors with the largest legal budget survive. Smaller actors hesitate. Researchers delay. Public bodies become risk-averse. Rights become a matter of institutional discretion rather than legal foreseeability. The real choice is not rights versus deregulation. The real choice is speculation versus disciplined realism. So let me address the fragmentation argument directly. EDRi worries that if the same data set can be personal data for A, but not for B, the GDPR becomes fragmented. The law becomes inconsistent. Companies can exploit uncertainty. Rights become dependent on the corporate perspective. That sounds serious, but it rests on a false choice. The false choice is between total abstraction and atomization. Total abstraction says Identifiability exists everywhere because it exists somewhere in the ecosystem. If any actor can identify, then all actors must be treated as if they can identify. Atomization says each actor is sealed off from everyone else. If B says it cannot identify, the analysis stops there, even if the wider processing arrangement makes re-identification foreseeable. Both positions are wrong. Realism is neither total abstraction nor atomization. Realism says apply one legal test to the real processing environment. Count the technical, organizational, legal, and contractual facts. Count built-in relinkage routes. Count enrichment paths. Count on disclosure risks. Count hostile incentives when they are relevant. Count anti-circumvention safeguards. But do not pretend that speculative identifiability everywhere is the same as means reasonably likely to be used here. That is not fragmentation, that's legal discipline. The fragmentation argument also misunderstands what uniformity means. Uniformity means a common legal test. It does not mean identical outcomes for actors in different factual positions. If controller A has the key and recipient B does not, why should the law pretend they are identical? If recipient C has a data graph that makes relinkage realistic and recipient B does not, why should the law pretend they are identical? If a data set is placed in a secure research environment with technical separation, contractual restrictions, and no relinkage route, why should the law treat that environment as if it were a data broker with a device graph? The answer cannot simply be because broader feels safer. Broader is not always safer. Sometimes broader is just less precise. And precision matters because the GDPR is risk-based. If the law cannot discipline its trigger, then risk calibration happens too late or not at all. The perimeter consumes the whole analysis. We spend our energy arguing about whether everything might be personal data instead of focusing on where people actually face meaningful risk. The alternative to contextuality is not certainty, it is a universal scope of fiction. So let's turn to SRB and the single resolution board litigation. This case matters because it precisely exposes the structure of the identifiability inquiry. It does not solve every future question. It does not give anyone a magic wand to declare pseudonymized data non-personal. And it should not be overread, but it should not be underread either. The EDRi move is to fence off the case. We are told that SRB is fact-specific, that it should not ground a broader legislative rule, and that it's too narrow to matter much for the omnibus. There is a grain of truth there. SRB is fact-specific. All serious identifiability analysis is fact-specific. But the fact-specific nature of the case is not a reason to ignore its legal structure. It is the point. So what does SRB actually confirm? First, identifiability cannot simply be assumed in the abstract. The law must ask who is said to identify, by what means, and in what processing context. Second, synonymous data do not automatically constitute personal data in all cases and for every person. That does not mean pseudonymized data are automatically non-personal. It means the answer depends on the relevant actor and the realistic means available to them. Third, the relevant perspective depends on the processing situation. The court's analysis was careful. It did not say perspective is irrelevant. It said that for the controller's information obligation at collection, the controller's perspective at the time mattered. At the same time, the judgment confirms that, for others, synonymization may effectively prevent identification depending on the circumstances. That is exactly the sort of disciplined realism the omnibus debate should confront. The danger is not reading SRB into a complete code. The danger is that draining a realism-reaffirming judgment of its significance makes an abstract theory of scope harder to maintain. So EDRi is right to warn against weak safeguards. It's also right that controllers should not evade obligations through cosmetic pseudonymization. It is right that downstream disclosure and re-identification pathways matter. But these points do not defeat SRB-style realism. They prove why realism must be done properly. The question is not whether SRB mechanically resolves every future case. It does not. The question is whether SRB confirms identifiability has a realistic, actor-sensitive structure. And on that question, the answer is yes. So now we have to talk about power. Ambiguity is not neutral. That doctrinal fog reallocates power. When the legislator does not clearly set the perimeter does not disappear. It gets set elsewhere. It gets set through guidance. It gets set through enforcement signals. It gets set through litigation risk. It gets set through private compliance folklore. It gets set by whoever has the resources, the authority, or institutional positions to define the boundary after the fact. Who benefits from that? Well, supervisory authorities and the EDPP gain de facto perimeter setting power when the threshold remains unstable. That is not a claim of bad faith. It is an institutional fact. A vague legal trigger leaves more work for interpretive bodies. Soft law interpreters gain power for the same reason. Guidance becomes more central when legislation is unclear. Alarm-based advocacy politics benefits from the fact that every clarification can be reframed as a rollback. If the base lane is maximal uncertainty, then any attempt to discipline the test appears to weaken. And large actors with large legal teams benefit because they can survive that uncertainty. They can document, negotiate, litigate, lobby, and absorb risk. So who pays? Well, SMEs and startups pay. They face compliance anxiety without the legal machinery to manage it. Researchers pay. They work near the margins of uncertainty and often lack the resources to design elaborate compliance architectures. Public bodies pay. They need workable rules for classification, sharing, anonymization, research, emergency response, and data reuse. Ordinary market actors pay. They get clarity late, often only after interpretive drift have hardened. And individuals pay too. Rights are not strengthened by making the system harder to understand. If people cannot tell when the law applies, why it applies, and who is responsible, protection becomes less intelligible. So the political economy of vagueness is not progressive by default. It can entrench incumbents. It can empower bureaucracy. It can turn rights into a moving target. This is why the legal certainty argument is not a corporate convenience argument, it's a rule of law argument. If the practical scope of the GDPR is set by soft law, enforcement posturing, and compliance folklore, then democratic perimeter setting is weakened. The legislature should set the perimeter. Regulators should enforce and guide within it. Courts should review it. Organizations should be accountable for applying it. That is called legal order. So this debate matters far beyond Article 4. The GDPR trigger is now a hinge for the wider digital acquis of the European Union. It now affects AI governance, consumer protection, competition, platform law, cybersecurity, media regulation, data sharing, digital health, research, and public administration. Yes, it also affects ad tech, but think about how much bigger data protection is than just ad tech. If the trigger is unstable, everything gets pulled into a GDPR scope fight. A consumer protection issue becomes a personal data issue. A competition issue becomes a personal data issue. An AI safety issue becomes a personal data issue. A cybersecurity or a public sector sharing issue becomes a personal data issue. A media or research issue becomes a personal data issue. Of course, many of these domains involve data, but not every digital harm is a data protection harm, even when data appears somewhere in the chain. The GDPR is strongest when it governs the problems it was designed to address. Personal data processing, lawful bases, transparency, security, data subject rights, accountability, purpose limitation, minimization, and risk-based safeguards. It becomes weaker when it is forced to carry every digital governance problem through the single doorway of personal data. That is why a clearer trigger matters. A clear trigger stabilizes the boundary between data protection and adjacent regimes. It lets the GDPR do the work it's meant to do without inappropriate heavy lifting. It lets other instruments address their own problems at the right layer. It involves systemic coherence without denying foreseeable re-identification where it is real. This is not narrower rights, it's a more coherent rights architecture. Take AI. If the real concern is discriminatory output, manipulative deployment, unsafe automation, or market concentration, the legal answer may involve equality law, the AI Act, consumer law, product safety, competition law, or platform governance. GDPR may also apply, but it should not be used as the default lens for every problem merely because data appears somewhere in the system. Take research. If secure research environments, technical separation, and robust governance can make identification not reasonably likely for a recipient, the law should recognize that. If, on the other hand, the research environment contains built-in relinkage, the law should count that as well. A stable trigger does not mean blind deregulation. It means the right law for the right problem. The rebuttal's broader point is constitutional. Perimeter setting affects the whole acquis, not just data protection doctrine in isolation. So what is the Omnibus debate really about? It's about a governance triangle: rule of law, legal certainty, and systemic coherence. The rule of law means the legal perimeter should be set through legislation, not left to drift through guidance and enforcement. It means actors should be able to understand when the law applies. It means individuals should be able to understand who is responsible. And it means regulators should have a clear mandate and courts should have a clear standard to review. Legal certainty means realistic trigger logic for all actors, including SMEs, researchers, public bodies, and smaller market participants. It means Article 4 is not a metaphysical speculation exercise. It means Recital 26 is taken seriously as a disciplined test of means reasonably likely to be used. Systemic coherence means the GDPR does less inappropriate heavy lifting across the wider digital acquis. It means consumer law, competition law, AI law, platform law, cybersecurity law, equality law, labor law, and media law can all do their proper work rather than being collapsed into a personal data trigger. This is the governance case for the Omnibus. Now I want to be very clear. Defending legislative clarification does not mean defending every drafting choice. There are real questions about downstream recipients. There are real questions about anti-circumvention language. There are real questions about how to evidence the absence of reasonably likely means. There are real questions about whether Commission implementing acts should ever be used to define what falls outside the scope of personal data, because scope setting is constitutionally sensitive. Those concerns should be addressed, but they're not reasons to preserve the flog and lack of clarity. There are reasons to draft better. The EDPB and the EDPS are right to insist that simplification must not come at the expense of fundamental rights. That's the correct baseline. The conclusion should not be that no legislative clarification is safer. The status quo also creates legal uncertainty. The status quo also shifts power. The status quo also fragments practice. The status quo also favors actors who can survive ambiguity. So the issue is not whether the Omnibus should be scrutinized. It is, and it should. The issue is whether we can distinguish bad drafting from a good principle. The good principle is this: a risk-based GDPR needs a stable trigger. So let me close by saying what we should keep and what we should reject. We should keep one legal test applied to real factual positions. We should keep contextual analysis anchored in means reasonably likely to be used. We should keep foreseeable linkage where the processing environment actually makes it real. We should keep downstream accountability, anti-circumvention safeguards, contractual discipline, technical separation, and evidence-based classification. We should keep democratic perimeter setting rather than permanent interpretive drift. We should reject the idea that context is fragmentation. We should reject abstract identifiability everywhere because someone somewhere could identify it. We should reject the underreading of SRB that empties it of significance precisely where it matters most. And we should reject permanent perimeter panic dressed up as legal certainty. The EDRi line promises stronger protection through vagueness, but vagueness weakens foreseeability, widens discretion, and hides policy choices inside doctrine. That's the wrong direction for EU digital law. A system that cannot clearly explain when it applies is not stronger. It is less governable. The law is not strengthened by a trigger that becomes harder to foresee, harder to discipline, and easier to stretch. It's strengthened when the trigger is intelligible, when risks are counted honestly, when safeguards are real, and when institutions stay within a clear democratic perimeter. Rights need realism. Law needs discipline, and fog is not a fundamental right. So thank you very much for watching this video. I hope this lecture has made clear that this debate is not really about being for rights or being against rights. It's about whether we want a legal framework built on realism, discipline, and democratic clarity, or one built on panic, abstraction, and interpretive drift. My own view is that rights are not protected by vagueness for its own sake. They are protected when the law is clear enough to be applied properly, strong enough to discipline real risks, and coherent enough to work across the broader digital landscape. That is why the omnibus debate matters so much. It's not a minor technical dispute. It's a test of whether lawmakers are prepared to get the trigger logic of the GDPR right, and whether Europe is prepared to regulate, with both seriousness and intellectual honesty. If you found this useful, please keep following the series, keep sharing the lectures, and keep returning to this discussion. The more clearly we explain what is at stake, the more pressure we can put on lawmakers, institutions, and commenters to get this right. This conversation is not over, and it should not be. There is a great deal more to say, and I will keep saying it. So thank you again for your time, for your attention, and for your interest in these issues. Please do come back for the next lecture in the series.